take steps to change their life. It's incredibly challenging to be in any situation.
Welcome back to my channel. Some of you yesterday were a little skeptical about whether or not I had found the lawsuit that was tied to the exclusive subpoena, but it turns out I was. Right, because not only was it the lawsuit Blake Lively's attorneys have admitted it was the lawsuit, Brian Friedman has gone on record and said he knew nothing about this lawsuit, and now there is an entire new dispute that is going to happen in court, because Brian Friedman has already indicated that the use of the lawsuit that without a crystal ball discovered yesterday in our research as an abuse of the legal system of the process. This could mean very bad news for Blake Lively, and the lawsuit was filed in New York Supreme Court in their civil division. The lawsuit was filed by a company that is owned by Blake Lively. It's called Vanzen Inc. Vanzen Inc. was originally established in Delaware by Eric Rothschild, and this company wasted to Blake Lively. Now Blake Reynolds, the company has gone through several different iterations, and there was a branch in California, as well as another one, that she opened in New York in 2019, according to the records obtained from the various secretaries of state. There's been multiple addresses used for this company, the address referenced in the lawsuit filed against the anonymous Jane Does, where they issued the subpoena, is connected to the California Secretary of State records. And while it appears that company Vanzen Inc. in California, while it appears as though it's active, the company is actually forfeited in the state of California through the tax board, meaning if you have a forfeited status in the state of California, it means your company cannot do business in the state of California until you get into good standing. And I went ahead and I searched the California Tax Board TOSI. We're still forfeited and not in good standing, and I received a letter which states that Vanzen Incorporated, this entity, is not in good standing with the Franchise Tax Board. If your company is not in good standing, it means that you owe money and that you are not allowed to do business in the state of California. So the company has multiple different branches, and the Delaware company hasn't updated their records in years. This company is what I would think of as maybe a shell company. It has no purpose. It's just this company that exists. And this company has no ties to Wayfair, Justin Baldoni, Jen Ale, or Stephanie Jones. So the use of this company, in my opinion, was only used to conceal the identity of Blake Lively, because Blake Lively didn't file this lawsuit under her name. She filed it under her shell company. She was concealing her identity. And when you are using the courts to conceal who you are, and you're filing a case against no one but John Does, it means you can issue a subpoena to anyone, and no one has to be notified in the case. So in this case, she was able to file a subpoena and give it to Stephanie Jones. And under the law, Noon in that court case had to be notified, meaning Justin Baldoni, Wayfair Studios, and Jen Abel were not notified that their privacy was about to be breached under subpoena power. Anyone can move to quash a subpoena for a variety of reasons. And this did not afford Wayfair, Jen, or Justin the ability to contest the subpoena. Now some will argue, well, they still could have got him through this lawsuit. That's really not the point. The point is that they didn't have the information. They used a fake lawsuit to get the information from Stephanie, so Stephanie could work around her non-disclosure confidentiality agreement that she has with Wayfair. It was done, as many lawyers have assumed, after the fact, to probably cover up the improper disclosure that Stephanie had made to Blake back in August of 2024. So what have they actually said about this case? The Daily Mail a couple days ago helped Stephanie Jones by talking about this subpoena. They claimed they saw a copy of it. They said it was filed in the New York court. They said that it was not stamped, but they did not disclose what the lawsuit was. They didn't disclose who the parties were, but you better believe they would have known, but they intentionally withheld that information from the public. So did Deadline. Why? Because if the public knew that the lawsuit was filed by this dummy company, Vanzen Inc., and if it became public that there was the use of a shell company or an alleged shell company to fish for information and to abuse and sidestep the subpoena process and the actual ability for someone being subpoenaed and their records being subpoenaed, fight the subpoena in court, it wouldn't look good for Blake, right? And if people could read what the lawsuit was about, they would see that the case she filed it under had nothing to do with sexual harassment.
When my physical therapist enters, he looks like if Zac Efron and Fabio had a baby.
Italso would show that Stephanie Jones, who's not the actual party of the lawsuit, was subpoenaed 4 days after the lawsuit was filed. And even though the lawsuit claimed she didn't know the identities of who was involved, She knew exactly who to subpoena. Doesn't look good. So now they're calling this super shady. They're using my disclosure of the lawsuit. They're pretending they didn't know, and they're taking credit for my work because they're only doing this case now because I exposed it Daily Mail. Credit me, please, anyways. Back to the story, they said that lively, super shady legal tactic that set off the war with Justin Baldoni before he even had a clue. They say she quietly filed a months before her legal war with It Ends With Us co-star Justin. Baldoni, their investigation, uncovered the full story behind the obscure lawsuit. Oh yes, the information was dropped into your lap. Daily Mail by Emmy. Now the Daily Mail can reveal everything legal experts say the case appeared to be a sham lawsuit with one describing it as super shady, but what really matters is Baldoni's attorney Brian Friedman says this appears to be an end skirting the process to be able to secretly get these documents without having to give anyone notice. That would be an abuse of process. And we intend to take all action allowable under the law. So he didn't know about it. He suspected they did something like this, but he didn't know what lawsuit they used. And even though discovery is happening, you just got to know that people don't really cooperate a lot of times during discovery. And just because there's a deadline for discovery doesn't mean that they're going to hand over documents. A lot of times in cases like these, they will say they object and then they'll have to go through the motion to compel process, and Blake and Stephanie might object to providing a copy of the subpoena. Even though they've all referenced it, the mental gymnastics that people do in discovery is really aggravating, and I want people to understand that just because discovery closes soon doesn't mean that Wayfair or Baldoni or Friedman have the information. So Friedman said he had no knowledge about the lawsuit until Daily Mail contacted him and asked for comment. It's odd because if the Daily Mail had the subpoena, they could have told him what the lawsuit was, right? So they bring up the lawsuit, right, that I shared yesterday, which was filed by a lawyer. That represents Blake Lively's Samantha Casey. 4 days after the filing, the Daily Mail confirms that Casey issued a subpoena to Jones Works, and they also admit they saw the subpoena. Jones did not object to the subpoena and turned over a trove of private messages between Jen Abel and a former staffer at her PR agency who continued working. With Baldoni, the crisis management guru Melissa Nathan, she retrieved the messages from Abel's company-issued phone after Abel told her she was quitting Jones Works in July. They also note that Casey withdrew the lawsuit on December 19th, which he told you yesterday, and that the next day she filed her California Civil Rights Department complaint, which I told you. Yesterday, the Vanzan was founded in Delaware. I just told you that. Okay, now, people have done some research, I guess, the subreddit. The team. Justin Baldoni uncovered that the only work that Vanzan had done was they had imported some furniture to Blake's house that's in the country, and that the person that was listed on the for attention was Molly Caro, who is a PR officer, that was credited as a producer of a music video for Taylor Swift that Blake Lively directed. Okay. So the legal experts, Ron Zambrano, who's been on Popcorn Planet, said, this is a sham lawsuit generated for an ulterior motive which can be sanctionable for a waste of judicial resources. They intentionally did this to really work in a very specious and clandestine way. It's super shady. Another attorney, Peter Gleason, who's represented dozens of Hollywood clients, said, this looks like a ruse to try and interject legitimacy into obtaining discovery that is intended to be used in another cause of action. If that's the case, it's totally inappropriate. They also pointed out that it's highly unusual that a firm would sue its own staff and representatives without apparently even knowing who they are. Our friends over at Ask Two Lawyers, Keith said, it's very rare to sue only do defendants. It doesn't make any sense to me. It appears to be a fig leaf. But of course, Blake Lively's attorneys say, this Ezra Hudson says, do lawsuits are commonly and entirely appropriate legal tools for pursuing claims and uncovering the identity of unknown perpetrators. Fun lawful activities, the lawsuit, unearthed the Wayfair party's documented plan in their own words, in their own text messages to destroy Blake Lively. Their full outrage has nothing to do with the legal ethics or the law, which are not an issue here. It's entirely about the fact that they got caught doing something.
Ever put more pressure on me than I put on myself, but I see it as an opportunity. You know, we have a responsibility to take care of a book that
they insisted would be untraceable. And then another LA attorney, Lincoln Bandlow, said it was no too unusual to file a lawsuit against unnamed defendants if the plaintiff TIF doesn't know their names yet. For example, in a defamation case against social media users, all she did was use Vans to avoid attracting media attention if they're trying to stay under the radar. It's not surprising, there's nothing unusual about using this kind of mechanism to uncover who's doing things to you that you believe are improper, okay. I want to say something if you've not been a part of the civil litigation process. Normal people do not have the power or the resources or the money to start lawsuits like this. You or I would likely never file a lawsuit against someone we don't know, or have the identity of, because why would you spend 30, 40, 50, 000, whatever it is, 20 million in a case that has no defendants, and then rack up legal expenses to figure out if someone said something about you or did something to you. This is a tool that's being used by someone that's incredibly wealthy to obtain information where she knew exactly who she was going for. So my issue here is that she's using Doe defendants, not because she doesn't know the identity. She clearly knew exactly who she was going for, because 4 days later she went to Stephanie Jones' hoe. Else would she have known to go to Stephanie Jones if she didn't know who was involved? That's just a lot of gaslighting to try to act like what this was legal and ethical lawsuits like. This are not ethical, they're actually sanctionable. And if you're filing a lawsuit like this to get access to information that you otherwise wouldn't be allowed to get, it is an abuse of process. So Baldoni's lawyers referenced that they would be seeking all legal remedies, including abuse of process. So let's talk about if they can add legal claims here. Abuse of process ultimately is going to help Baldoni and Wayfair strengthen their case in their effort to prove malice, because what they can do is they can sue her now. And Jones works for the abuse of process. They can argue that the lawsuit was done in bad faith. It was done for the sole purpose of obtaining information that was not connected whatsoever to the lawsuit. That had no claims, that they had no claims to receive that because it was done in bad faith. Because the information obtained, she knew where she was going when she filed the lawsuit. She filed it against no one, claiming that she didn't know the identities. And yet 4 days later, she sends the subpoena to Stephanie Jones. So she knew where she was going with this. And then they admitted that this was how they uncovered the text messages from Jones. Okay, so if they get the messages from Jones this way, they had to know where they were going. And if they don't sue someone, they can avoid the legal process of notification for subpoena. So they can use this as a bad faith argument. So it's usually required that a person who brings a claim for abuse of process will have to plead and prove that injury or damages resulted from their regularity of the process. So in this case, what they could say is she used these in order to defame me with false allegations of sexual harassment. And she used this in order to cure Stephanie Jones's illegal release of confidential information that she gave to them before she had the subpoena right. Stephanie could only give information over if she had a subpoena that was in their agreement, and she gave it to them in August. And then in October, she gets a subpoena, so they're trying to cure that improper disclosure, right? And they're trying to help Stephanie avoid getting a breach of contract lawsuit. They're interfering in Stephanie's contract between Stephanie and Wayfair. And it says persons using a legal process with malice in order to attain a personal purpose, not similar to what the crux of the litigation are liable. For intentional tort of abuse of process, any person who procures unnecessary and improper initiation of process by a third party will also be liable for damages for abuse of process. If a non-litigant who actively participated in a civil proceeding that results in the improper initiation of the proceedings, he or she can be liable for damages for abuse of process. So Stephanie Jones was not named right, but she's a non-litigant and she actively participated in this procedure, so she can also get abuse of process, as well as basically what this law firm is saying, so it adds legal liability, or could add legal liability to Blake Lively and to Stephanie Jones, but it also creates another problem for her attorneys, because if Wayfair wanted to, they could also file a motion to have her attorneys disqualified, and they can argue that the attorneys participated in the abuse of process, which would be considered an ethical violation and misconduct.
What Lily has experienced have felt really seen by it. And I'm not saying every woman would, just the ones that I know that have seen that.
And they can argue that it undermined the integrity of the judicial process. And an abuse of processes occurs when an attorney uses a legitimate legal procedure for an improper or illegitimate purpose, often to harass, intimidate, or gain an unfair advantage. Here's the thing, if they don't notify Baldoni and Abel about the subpoena, Noon can contest them getting that information. Okay, when they tried to get a ton of information from Baldoni and all of the parties through their really broad, subpoenas that they issued from the phone records and from all the different phone carriers, and they wanted 2.5 years of this, and they wanted all the documents and all the texts, what happened in court. the judge quashed it and said they were invading their privacy. So what would have likely been an outcome in the New York court would have been similar. They could have quashed it for that same purpose by bypassing the ethical responsibility they had to legally notify Abel and Justin. They were able to obtain information that they otherwise would not have been able to obtain. Besides disqualifications, courts can impose sanctions, such as fines or monetary penalties for attorneys, misconduct including abuse of process, and examples are using discovery requests to harass or intimidate a party rather than a legitimate formational gathering, filing frivolous lawsuits or motions to delay or derail the proceedings. Misrepresenting facts to using deception to manipulate the court attorneys have an ethical professional duty to uphold the integrity of the legal system, and ethically abuse of process violates their ethical obligations. So it helps them if they want to prove malice, obviously it has to be going to a jury, but I think this kind of strengthens their case, and Blake's side will say, well, you're just mad that you got caught. That kind of feels like you're doing the reverse perpetrator offender right, because it's like saying, we did something, but you're just mad I got caught. What did they get caught doing talking about a plan that could be used online to help him? Defend against claims that he sexually harassed her and was asexually a sexual predator that was never implemented by anyone. What were they caught doing? Because Blake gave the New York Times a sentence of an actual text message, but the omitted portions show that they weren't doing what she claimed they were doing. And sure, some of the things that they said weren't great. It's not nice to say you're going to bury anyone, right? But let's just say here, just because someone says, I want to feel like I can bury her, that doesn't necessarily mean that's what happened. It could have just meant that he was very emotional when this was happening and going on, and he was very frustrated. I feel like I would be too if I had to deal with Blake Lively. Have to look at communications in their entire context, in their entire totality. You have to be able to see everything to actually prove intent and to prove what happened. And in this case, if they knew that they would have been able to show that in their complaint and her smear campaign thus far has falsely accused content creators of working with Balon, when they haven't been content creators going on record with the New York Times and saying, I wasn't involved in this. She's been accusing Balon's side of leaking information. In fact, people were in on Reddit suggesting that maybe got this leaked to me from Friedman, and that's not true. I found this myself. Blake doesn't want to believe that there's just people online that don't like her, and Balon had nothing to do with that. Is it right that people don't like her? I don't know. Is it wrong that people got mad during the promotion? I don't know. I don't think so. Did she talk about domestic violence in promotional interviews? A little bit, but not really, not to the extent that people wanted. I think people were the most offended with her self-promotion and repeatedly saying, it's not a film about domestic violence. It sucks when the tides turn. It sucks when you get quote-unquote canceled. But nothing on the internet is forever, and everyone has an opportunity to rebrand themselves and to come back. But what she's doing here doesn't help, and it's just making
too far, allegedly, according to Justin, and I see the writing on the wall even reading this.
Because we're seeing the tactics she's employing to get information that she shouldn't be getting. And it just makes me wonder how often this tactic is being used by them to intimidate people. Because if you're using techniques like this, and you're up against someone like Blake, and you don't have the kind of money that she does, she could bury you in legal fees and force you to comply with things that you don't want to do. Because if you don't, she could file a malicious lawsuit against you and make up a lot of claims about you and humiliate you. So what are you going to do? Apparently you're going to do what she wants at her benefit, not at yours. That's my opinion. I think there's a lot of people online that are just looking for the information and trying to figure out what's going on. And because some sides are not being as open in what they have, it's forcing people to fill in those blanks. And the Daily Mail is now trying to take credit for my work and clean up their own cover-up that they did for Stephanie Jones. Just remember that a lot of these outlets are getting fed information by PR teams, and they are working for whoever they get the information for at the time. So what are your thoughts about this? Let me know. Do you think they will add new claims in their lawsuits? Do you think they could get disqualified? Do you think someone from Balon's side might file a complaint with the bar? Could they possibly be disbarred? Will they face sanctions? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.